So again, good afternoon, everyone, and thank you all for joining today's webinar, Trauma-Informed Approaches to Victims of Technology-Facilitated Abuse. This webinar is brought to you by OJJDP's INTAC in collaboration with the Zero Abuse Project. My name is William Moore with OJJDP's INTAC, and before we begin, I would like to go over a few housekeeping items to keep in mind. Please note that this webinar is being recorded. Note that this and past web events are archived on OJJDP's Multimedia page and YouTube channel. If you would like a copy of a transcript and supporting materials, we encourage you to please reach out to OJJDP's TTA Help Desk. If you're having any troubles downloading any of the event materials, please note that my colleague has posted a Google Drive link in the chat. Select that Google Drive link and you should be able to receive the materials related to today's webinar. If you're having any trouble accessing that Google Drive link, please reach out to the OJJDP TTA Help Desk, and we will be more than happy to get those materials to you. We encourage folks to please use the Call Me At feature in WebEx in an effort to get the best option for audio. If you're experiencing any technical difficulties during today's webinar, please contact me and I'll be more than happy to assist you with your issue. We will have an opportunity for participants to ask questions during today's webinar. We ask folks to go over to the chat window and you could type your question. However, before you hit send, go to the To panel and select all panelists and then hit send. We will take questions throughout today's presentation. Help us count. If you're viewing by yourself, there's no need to type anything at this time. However, if you're viewing in a group, meaning it's more than yourself and additional people are with you, go to the chat window and type in the total number of additional people that are in the room with you. Again, please do not count yourself, only count the total number of additional people with you. Be sure to select all panelists before you hit your answer. Attendees will receive a certificate within 24 hours of the completion of today's webinar. Please be sure to keep an eye out for your certificate. Here's the agenda that we will have today for today's webinar. Again, reminder to the audience, please be sure to go over and complete the poll question under the polling tab. That being said, I would like to now turn over today's web event to our moderator and presenter, Kathleen. Kathleen, whenever you're ready, take it away.
Thank you so much, William. Hello, everybody. Thank you, everyone, for being on here this afternoon. I'm coming to you from Central Time, so it is just a little bit after 2 o'clock for me. So hello to wherever you are logging on from this morning, this afternoon, this evening, wherever it is that you may be. My name is Kathleen Nolan, and I am a senior attorney with the Zero Abuse Project. And for those of you not familiar with Zero Abuse Project, at the last slide on here, there will be the website and some information. But if you aren't familiar with our organization, we are a nonprofit that is essentially dedicated to the goal of eradicating child abuse. And a big way that we do that is what we're doing here, training for child protection professionals, across the country. We do a lot to be able to get out in person as well as, virtually to train the people on the front lines that handle these incredibly important cases. And I have been with Zero Abuse Project since May of 2021. Before that, I was a prosecutor. I was a prosecutor in the state of Illinois for about 15 years, and I handled exclusively child abuse cases, child sexual assault, child physical abuse, child death cases. And throughout the course of my career, as our As our technology expands, I became more and more involved in technology facilitated crimes. I started prosecuting in 2005, 2006, in the very early days of, digital evidence and, the obtaining of pieces of digital evidence. That was kind of the start of my prosecution career. And through the course of my career, I have worked many cases. And the working of those cases is part of what inspired me to put this presentation together, because I recognized things that were different with the victims of these types of offenses and these types of crimes. And one of the things that we work on through Zero Abuse Project is something through a grant that comes from our Department of Justice and OJJDP, that is the Trauma Informed Prosecutor Project. And that's actually the next slide I'll put up here. The Trauma Informed Prosecutor Project is a grant that allows us to provide training and technical assistance to prosecutors, police, child protection across the country. And it allows us to do that free of charge because it is part of the grant. And so when I came to Zero Abuse Project and thinking about, what are things that people in the field need, thinking about this Trauma Informed Prosecutor Project, it brought me to the idea of, what can we get out there for trauma informed approaches to victims of these types of crimes, and how can we get some of that information out there to better equip our police, our prosecutors, our victim advocates, everyone that works in this field, better equip them to work with this particular population. So that is what we're going to talk about for the next hour plus. I do want to leave some time at the end for questions, and as William said, please feel free to chime into the chat, and if I see it and can get to it, I will answer questions as we go through. There are a lot of slides here. There's a lot of information. There may be things that I jump over just in interest of time, but you will have access to everything. And if after the end of today you have a question, you want to reach out and talk about something, please absolutely do so. This is my email address. So if there's something that I don't get to today, or something again that you want to pick my brain about, please do so. That's another piece of this grant, is that it allows us to do that technical assistance. And something that I really love about this job is getting out and talking with our first line or front line child protection professionals, and helping them do their job better. So a quick look before we get into things at our agenda. So these are the topics we're going to cover today. We're going to talk about some of the unique issues that are faced by victims of technology facilitated abuse, and talk a little bit about polyvictimization and digital crime. Discuss some of the pretrial challenges and how we can meet those challenges through some trauma-informed trial prep. And then the last piece that we'll talk about is some things at the end of the case, when your case is resolved, some things to be conscious of that are particularly applicable in our technology facilitated crimes. So that is what we are going to cover. A quick disclaimer that none of this is to constitute legal advice. Always consult your local prosecutors, your local attorneys, your local people that are involved, for your state specific jurisdiction specific statutes. Again, no legal advice here, but allowing you to reach out and talk with some of your local prosecutors if you need to. All right, so that is our agenda. Let's dive in and start talking about some of these unique challenges. So right away, I want to talk and highlight some challenges with terminology. So terminology, and particularly in this presentation, terminology and the words that we use are important. We know that words matter. And in talking about these types of crimes, the first kind of terminology piece I want to point out is this difference between child pornography and child sexual abuse material. And they are two different terms, and one is much more victim focused and one more preferred, and that's the child sexual abuse material. And on this particular slide, there's some information from NCMEC, or National Center for Missing and Exploited Children, that talks about why this language differentiation is needed. And it talks about the fact that, pornography doesn't really reflect the severity of what we're talking about. It doesn't really reflect the seriousness of what it is that we're discussing. And so, thinking about the use of that terminology, child sexual abuse material versus child pornography, when you're talking with families, when you're talking with victims, it's a much more informed term. Child pornography is a legal term. And there are some jurisdictions that have started to work to adjust their statutes and their statutory language. But essentially, child pornography is the term and phrase that has been used for years. Like I said, I started prosecuting in 2005, 2006, and child pornography is all that I have ever said in the duration of time that I've been doing this job. It's not until, diving into some of these more trauma-informed approaches that I've learned that child sexual abuse material is preferred. And so, as we're always learning, we are always trying to do better. I'm always now in my mind, kind of self-correcting. I want to use the right term. That being said, if you are in court, if you are charging something, if you are using language in a search warrant and your offense is child pornography, you need to use the correct legal terms. You don't want to charge something with the wrong term and give a defendant a technicality to be able to say this isn't even the right language, that it needs to be specific, it needs to be correct. And so from a legal context, that makes sense. But from a trauma-informed family, people involved in these cases, that type of approach, child sexual abuse material is much more reflective of what we are talking about. The next term here, and I have already kind of in my head flip-flopped a couple times on it, but the term is victim versus survivor. And it's a very similar kind of two sides of the same coin. Victim is a legal term, a term of art. It is used in jury instructions. It is used in offenses. Survivor is a little bit of a different perspective, and same. Citation here, National Center for Missing and Exploited Children, appreciating the wisdom shared by survivor advocates, explaining they live in a space of duality and feeling both victorious by surviving child sexual abuse, yet continually victimized by the memorialization and distribution of their material. It really goes to how survivors see themselves. Through the course of my career, I have worked with so many survivors that don't see themselves as a victim. We run into that a lot with some of our, teens or older kids, that they don't see themselves in that space as a victim. And so in wanting to be trauma informed in working with them, you want to respect where they are coming from. And, sure, there's having that conversation of, hey, when we're in court and I'm saying victim, I understand where you are coming from, what you are saying, and that I don't see you as a victim, but I have to follow the law. We've probably already had a bunch of conversations in your trial prep of there are rules in court and we have to follow the rules. I want to make sure I'm following the rules. So when I say victim in court, know that I respect where you're coming from. I'm just trying to make sure that we're doing what we need to do. And it's funny, as I'm saying that, someone chimed in the chat that kind of said the exact same thing. Letting victims know that it's a legal term, and when we're using it, it's not that I see them differently. I just have to follow the law, the legal parameters when I'm in court. So again, it's one of those that as I have spent, however many years in a courtroom, victim is my default. I'm always seeing victim. And it wasn't until I started doing more work with, advocates and survivors groups, the jurisdiction that I previously prosecuted in, we had a university, and I was very active and very involved in a task force to sort of reevaluate their Title IX policies and procedures. And that was when I really started hearing more about survivor versus victim. And so, it's one of those things that if you were in court, being conscious of your language, but being aware, why that different language makes a difference to them. All right, so these unique issues, what are some of the unique issues that come up, that are being faced by our kids, our teens, our people that are experiencing this technology facilitated abuse, technology facilitated crimes? And, when we say that, we're talking about, your online exploitation. Human trafficking is absolutely something technology facilitated. Online harassment, our traditional cases of, the sharing of these child sexual abuse materials, uploading, having access on the internet. There's a lot of different ways that crimes manifest themselves through technology. And as we continue to have more access, as there are more populations who have more access to the internet, the increase of that internet being used to commit crimes will continue. I mean, when we know so often that there is, sort of that principle of if there's something out there that someone can exploit, it's going to be used for criminal behavior, and the internet is absolutely no different. And the more access that our kids have, the more access that all areas across the country have, the more access people have to that internet, the increase in that exploitation will continue to be. And even our cases that are, your traditional child abuse, your traditional, hands-on cases are very likely going to involve a tech element. And when we myself and other members of our team go out into the world and train, especially myself and the other prosecutors and the law enforcement officers that we have on our team, when we're talking to prosecutors, police, we really do kind of drive home that it's rare now to have a case that doesn't have a tech or a digital component, that there's going to be something involving, even if it's just as simple as messages back and forth. Someone chimed in the chat, social media platforms. Absolutely. People that are engaging in inappropriate behavior on social media platforms, or using social media platforms to start that solicitation. And I actually have a couple slides coming up that get into some facts and figures from National Center for Missing and Exploited Children as to how online platforms are being used to facilitate that communication. So, as that access increases, the likelihood of exploitation is going to increase. And so a couple more things. Again, National Center for Missing and Exploited Children is an amazing resource for this. There's, a lot that in doing research and me looking to things that'll be helpful, a lot of what we look at comes from NECMEC. But, one of the differences from our traditional hands-on offenses is that there is this permanency, this ever existing record of their abuse. And so, when we're talking images, videos of the child sexual abuse material, especially your older kids, are aware that the internet is forever, that something that is put online is really difficult to completely purge. And so they live with this kind of continuing fear that their abuse, the most horrible thing that has happened to them, it's recorded and shared. And the likelihood is that that will be available and accessible forever. And anyone who wants to see it can see it. We know the trauma of abuse and the internalization of that trauma is really difficult and really hard to, overcome just in and of itself. But when you know that that permanent record exists and is out there, it's just that added piece, that added layer of trauma. And there's a possibility that this will be available out there and may continue to exist into adulthood. And some tools and some things that we can do to combat this is part of what I talk about at the end. But this is just sort of highlighting why these types of offenses, these types of crimes are unique and have a different set of trauma attached to it. And so the way that our law enforcement officers, our prosecutors, and the people that are involved with these victims of child sexual abuse material, the way that some of those first contacts, those preps, and those sessions that are, working our victims, our survivors, our families through the court system can have a huge impact on that process, understanding how difficult that is, really can go far to helping the mental health component, and that support for victim, the support that is provided, through law enforcement, through the investigation, through prosecution, into the prosecution stage, really help move them towards a healing space. I had a case a number of years ago that involved or started as a disclosure of sexual abuse hands-on from biological father. Girl had come in for an Aaron's Law presentation, which is in Illinois, a law that was pushed by a survivor, Erin Barron, who is an amazing advocate for kids, if any of you have ever come across her. But an Aaron's Law presentation in school basically gives kids the tools to, understand, their body and their safety, and maybe come forward with something if they're not so sure. And this little girl came forward and, asked the teacher, hey, does it count if it's your dad that's doing the touching? And so that sort of kicked off an investigation, which resulted eventually in the biological father pleading guilty to the hands-on acts that the girl had disclosed. And a number of years later, we were notified through Department of Homeland Security and through one of the local police departments, that some videos had been found online, and it actually took them quite some time to identify. It's that could probably be a whole other presentation, but through a lot of really hard work by some really great people, they were able to identify this girl and the dad in the video. And so we spent a ton of time looking at double jeopardy and, can we charge something else now that we know these videos are out there? And, our answer was yes, because she hadn't disclosed anything about videos of child sexual abuse material, primarily because she didn't know. She didn't know that any of this was ever recorded. And when these came back out, she was in her teens. She was 17, 18, and, we moved forward with charging, and we got very close to having to go to trial on this. And myself and the other prosecutor were very, very conscious of the trauma and the huge, huge burden we were putting on this victim, who's still a child, has been through so much. And we leaned so heavily on our team of advocates, counselors, to make sure that she was always in a good headspace where we were going. And we were able to plead it to something really high, essentially ensuring that he would never be able to get out of prison. But that mental health component was very key to our moving forward on that case. And even before, we charged the child sexual abuse material, the child pornography piece of it, we reached back out and set up a meeting and talked, so she understood where we were coming from, but also so that we could again put out there that her mental health and her stability was important to us as well. And that was, a great relationship and worked out really well. It was a great result, but it really having that mental health understanding from all of your players is going to go very far. And I distinctly remember at some point during that thinking, they don't teach us this in law school. This is not something that, ever in my 1L, 2L, 3L years taking the bar would I have thought this is going to be something that me as a prosecutor am going to be tasked with, this responsibility. We don't teach it. We don't do a lot to help our protection professionals understand this. And that's actually something through Zero Abuse Project that we were working on. We were working on a website, a platform called Survivor Space that is going to give more tools and more resources to those that are working in this system, in addition to tools and resources for our victims and survivors. But there's a lot to consider when we have these unique type of issues in our technology facilitated crimes. Some other issues that come up, things that are just unique, fear that their images are going to be seen by people that they know. Sure, there's a lot of this stuff that's out on dark web and like weird corners of the internet, but there's things that aren't not necessarily, they may be somewhere mixed in with something that it could be accessible by other people. And even if it's not a rational fear, even if we know that these things are, heavily restricted, or, that law enforcement has done their best to remove those things, that fear still exists, and it's a valid fear. The fear that those images are going to be online forever, and those feelings of re-victimization every time that particular image is shared. And in the story I just, or the case that I just shared, that was something that was brand new to this victim. She didn't know that those had been out there, and then kind of processing that in the 6 or 7 years since her initial disclosure that those had been out there and been shared was a lot. And it really was bringing back that victimization all over again. That worry, that fear that you're going to be recognized in the real world, that maybe someone is going to recognize you. I can't go through a presentation without referencing, some type of Law and Order, but, there's an old Law and Order SVU episode that's essentially like the plot line, that there's this girl who was a victim of, horrible child sexual abuse videos. And one of the people that was, watching these videos, tracks her down in real life. So, sure, we know that SVU was ripped from the headlines, but not necessarily always accurate. But it's again, it's a fear, and it's a real fear that victims and survivors have. Oftentimes, you see extreme actions, things that they're doing to try and destroy materials. And these are those cases that you see where, something's going on and the way that law enforcement is alerted to it is because of an arson or a theft. I'm thinking a number of different cases where, kids have broken into somebody's home to steal their image, to try and get that computer back. Again, set on fire, we're going to set the whole house on fire because this is where this happened to me and I want to get rid of all the material. Some of these extreme actions. Financial loss, it can play in, partly through what we know about our adverse childhood experiences study. And that, kind of runs along financial loss as well as, physical health. But, kids that have experienced extreme trauma that can't process it are not going to excel at school. They're not going to do, their best work. And that's going to impact long term. If you can't process, if you can't be in a space where you're doing good work, no matter what it is, if it's school, if it's in a trade, whatever, if you can't move yourself forward because of the trauma you've experienced, then you are going to experience, a loss in other areas of your life, financial being one of them. And then the last piece too, I'm actually going to spend a little bit of time talking a couple sort of case studies about this last one. Case studies, examples, things that I've encountered in my prosecution career, but that not being ready to disclose. And that comes up in our child exploitation cases a lot because we know that there's so many things that are out there, so many agencies that are out there, monitoring. They're watching internet traffic. They're looking at our social media platforms. They're getting alerts through all of our different internet service providers, saying, hey, here's this material. And a lot of times that's material that, if we can find the child in it, the victim in it, we may come across a situation where the child has not disclosed anything. And so when you are put in a position where you're being confronted with something that you weren't ready to disclose, it can be difficult. What we know about the process of disclosure, what we know about our kids that are sometimes trying, that trickle disclosure where they're, trying a little bits and pieces to come out. What we know about dynamics of abuse, if perpetrators in the home, if perpetrator is someone that's loved and trusted, how that impacts our kids' disclosures. We know that it's a process and we know that it's difficult. And so when that choice is taken away, it can be difficult to sort through. So here's a couple examples. So first example here is a case involving two, they were twins. They were twin 9-year-old girls. And they had a family friend. Their mom had a family friend that they regularly went to go and visit. And mom did not have any concerns. Mom did not have any reason, did not believe that they were at risk at all, was very thankful to this friend of hers who regularly volunteered to take the girls to go and do things and regularly would have them sleep over, spend the night. They were never at the defendant's home together. They always just went one at a time. But the girls regularly went to visit, were over there, and one afternoon, mom was bringing bringing one of the girls to visit and is surprised to find that the house is being held by law enforcement officers. And the law enforcement officers in Madison County Sheriff's Office that I worked with at the time were present at this defendant's home because we had executed a search warrant there that day for child pornography, for child sexual abuse material. And when mom and these two girls approached the home and said, mom and the girl approached the home saying, hey, we're here for the weekend visit. Obviously that raises alarm bells for our law enforcement officers, that they know that there is someone, the person that lives in this home is actively downloading child pornography. In fact, in this particular search warrant, when they came in the door, he was in the shower, but was actively downloading a torrent that was full of child sexual abuse material. Also learned in some digging that he had a prior conviction for child pornography out of the military that mom had known about, but he had showed her a letter from the military saying that it was all a mistake and he didn't really do anything, and mom believed him. So again, this is another case that could be a whole case study in and of itself. But we have this situation where we now have, I'm going to shut my window there, lights getting a little bright. We have this situation now where we know that someone is interested in child sexual abuse material and has access, unrestricted overnight access to children. So we do what we do. We work our cases and we want to talk to these girls, even though they have not made a disclosure. And at that time, we had not found any video specifically of these girls. We still wanted to talk with them. In the course of doing the search warrant, and this is, the actual house here, we found some things in the home that were a little concerning. This little drawing here that was in his bedside table, clearly, a child's crayon drawing. He was single. He didn't have any kids. There was no reason for us to believe that that was something that, was from a family member. It was concerning. So, we want to talk to these girls. We want to see what's going on, and so we bring them in for a child's advocacy center interview, and neither girl disclosed any abuse. They talked about going to the home, they talked about spending the night, they talked about doing all of these things. One of them, which was LARPing, which I had never heard of and had to learn a lot about LARPing, which is live action role play, for those of you that don't know. And they didn't disclose anything inappropriate. Their demeanor was definitely concerning. They weren't talking about going there in sort of like the happy-go-lucky, joyful that you would think a child would talk about, going to see a trusted relative. It was a little reserved. It was a little held back. And when we interviewed them, there had been one piece of evidence that was found, and on the bullet point here, it's called the tutu video. And that particular video showed one of the girls, and it was tough to figure out who, because again, they're identical twins, kind of doing gymnastics, and he's recording her, and it's a creepy video. And both girls were asked, that this video doing gymnastics, is that you? And they both say, no, it's my sister. So neither one of them are admitting anything. They are not disclosing abuse. And, we have this issue that, again, with the one video so far that we've seen, we're not sure which one it is because they are identical twins. And so, what ends up happening with this particular case is we continue to work it. We do, our law enforcement does what they do, and they begin to go through all of the media that was found in this home. And one of those pieces of media was a very small little scan disk drive or a scan disk card from a camera, a handheld camera. And that was something that an investigator picked up in that bedroom, logged as evidence, and it took a couple weeks. But when that piece of evidence was viewed, there were about 18 homemade videos that we located that involved both girls, and very clear, very graphic examples, or very graphic instances of sexual assault that he had recorded. So we now have photographic video evidence, and we know it was both because we actually had to have mom view some sanitized images to identify them, and she was able to identify them through some facial characteristics that were slightly different. But so both of these girls have been brought in for a forensic interview, a child sensitive interview, and neither one of them disclosed. And we now know that they in fact had been abused. And so, trying to process through that case was difficult because, we don't have a disclosure. We don't actually have a disclosure from those victims. And we had a plan that was kind of involving, having them go into counseling, and then maybe we would revisit the situation some months down the road. And there was a number of things that happened with that did not allow us to go that path. But the victim identification piece is a pretty big piece of the charges, primarily because in the state of Illinois, if someone is convicted of what are called predatory criminal sexual assault charges with 2 different victims, it's a mandatory life sentence. So, our having to prove up the acts with those 2 victims was basically the difference between life and not life. And throughout the course of the case and prepping that case, the girls never disclosed. It has been a number of years since I've had contact with that family, so to date, I'm not sure if they have disclosed. But getting up to trial, they had not disclosed, and that was a case that our evidence was very compelling. We actually ended up pleading it open, allowing the judge to make a decision as far as the sentence, and he was sentenced to at the end of the day, I believe it was 85 years in the Department of Corrections. So, there was some pretty significant charges and significant sentences we were able to put together because of that video evidence. But it really, for the purposes of this, it's the fact that, we know something happened, but the girls weren't in a place and may never be in a place to disclose. Another example here, different case. This involves our social media, and this was a case where a perpetrator, a biological father, had been communicating with his daughter over Facebook. And in the course of some of those messages being exchanged, there were pictures that were exchanged, and Facebook flagged them and notified the state ICAC, which then it was sent to the appropriate police department to investigate. So, we knew perpetrator, the police department that received this information, was able to, look at the things that were being exchanged, do some pretty quick work as far as background, to figure out, that the victim in this particular case was, someone that was related to him. And so, we came up with a plan, and the fact that we know that these images are being exchanged, what is being discussed in those chats makes it very clear that there has been hands-on abuse, but we don't have a disclosure. And so, trying to come up with a plan of how to talk with this child about what's going on in her life, knowing that she has not chosen to disclose it yet. And this was a situation that, our team really worked closely because we wanted this to be a victim-centered approach, and we wanted to be able to be, trauma informed with what was going on in her life, but also, knowing that this is out there, that we have hard evidence that something is happening to her. And so initially in that CAC interview, she, said, nope, nothing I want to talk about, all good. And, we sort of regrouped and had the interviewer go back in, which is some of the chats, and, really phrased it of, sometimes there are things going on in kids' life that police learn about, that, DCFS gets involved in. And, this is one of those times, and, they've read some of these things and they're concerned, and that's why we're here to talk with you. And so then, she did come forward with it and gave a very detailed disclosure. In that particular case, he ended up giving a very detailed confession as well. So this was something that we also moved forward with a plea. There is a negotiated plea for a number of years, and he pled to about 25 years, 85% in Department of Corrections. But part of that was working with our victim, that she was in regular counseling, weekly, if not multi-weekly, counseling with our in-house child advocacy center therapist. And then, once we got to the point of, hey, we're going to be able to resolve this with the plea, they started working on her victim impact statement of how she was going to talk with the court about what happened to her. And a big piece of that victim impact statement was talking about her feelings about the fact that this had happened, and she didn't really get to disclose in her own terms, because of how this case happened and rolled out. She was kind of put in a position where she didn't necessarily have a choice to disclose, that it's, she talked about weighing those, I don't want to disclose, but I know now, since the police know, that it's going to stop. If I'm talking about what happened, it will stop. But the fact that she didn't have that choice was something that she really had to work through. So it can be really difficult to put our victims or survivors in that space, where we know that their safety is at risk. We know that they are experiencing things sometimes in the home that they're being exposed to and haven't disclosed, but we need to ensure that they are safe and that we can move forward with that case. So just kind of highlighting some of those unique issues, unique problems that can pop up during the course of the investigation. So, how do we address this? How do we pull that team together? Both of those examples that I just used involved, a number of different players, from police to our counselors to, prosecution to judges, all of that. And when we're talking about our technology facilitated crimes, it's good to look at it almost in the context of sometimes like our health, our medical health, and looking at sort of a continuum of care. How can we establish a continuum of care for our families, for our kids, as they navigate these different systems? And so when we're, looking at how we can do that, looking at all of the different services, it really is best practices to integrate those services so that there's not a gap, that we don't have families coming in to our child advocacy center and, having some discussion about counseling and then never hearing anything again. From the prosecution perspective, there's so many cases that we can't charge, that day. But having that, hey, we'll keep in touch and we'll make sure that you know what's going on, and those kinds of things, will help sort of fill that gap between the process and the people. And so, when we're talking about that continuum of care, there's so many different pieces that we want to make sure are part of this process. And mental health is huge. I cannot say enough about how preserving that mental health is going to be real key to pushing your cases. But involving our attorneys, our law enforcement, making sure that the caregivers, non-offending parents, or in cases where it's stranger online exploitation, the family in general, understand what's going on, and understanding that a lot of these other pieces are going to be necessary to work together. Incorporating our medical, my multidisciplinary team, we had amazing medical. I practiced in downstate Illinois, so right across the river from St. Louis, so we were in the St. Louis metro area. And our medical, as far as our multidisciplinary team, were parts of two amazing children's hospitals in St. Louis, Cardinal Glennon Children's Hospital and St. Louis Children's Hospital were fantastic, and they were active parts of our multidisciplinary team. Having our victim advocates, involved and part of that team is going to keep a lot of those spaces filled in, especially if you have something that isn't charged right away, that there might be a delay, that we know once cases get charged, there's even more delay after that. Incorporating our child protection, because we want to make sure that kids are safe, particularly with our perpetrators in the home, our non-protective caregivers, those things. We want to make sure that that conversation is happening with our people that work the child protection, and are all on the same page. Getting our prosecutors and judges on board. Education is absolutely helpful. Our education piece, if there is something going on, and it's going to affect their school. The number of times that I've had to work with parents to figure out school schedules. If there's something going on that we needed to write a letter, but maybe parents didn't want the school to know exactly what was going on. Getting everyone on board with having again, that communication aspect. Probation and parole, that's sort of for the after effects, making sure that victim no contact orders are being maintained, that distance, residency distances, things like that. And then pulling in our media and our tech. The more that our technology is involved in these cases, the more we need the cooperation of your Facebook, your Google, your Snapchat, to be able to be combating this technology facilitated abuse and getting us the information that we need. So, thinking about it in sort of this context of not just one piece, not just everyone acting on their own, but pulling all of those team members together. And sure, it's not as clean or protocol as our multidisciplinary teams, but seeing that there is huge benefit to having all of these different parts looking towards the best interests of our victim. And knowing that the mental health and that aspect of it is incredibly important to be conscious of, that we want to start that trust, that communication from the start. And particularly with our kids who are kids and teens who are subject to human trafficking, subject to online exploitation. We know that there are a lot of people in their lives who have failed them already. And a lot of those people are adults. And I forget that I am an adult. I forget that sometimes, the kids and teens that would come in to meet with me are seeing me as an authority figure, as a prosecutor. And, not even to mention the early parts of the investigation if there's police involved, especially again, our trafficking kids may have had negative interactions with police, may have not, had those really positive circumstances and interactions. And so, understanding that trust, that buildup starts from the ground up will help them see that you are sure you're another adult, but you're an adult that truly has their best interests at heart. So, just a real brief piece here then about polyvictimization. So, polyvictimization is something that we are learning more and more about when it comes to child maltreatment. And the concept of polyvictimization isn't that children are exposed to repeated instances of maltreatment, which we know it does happen, but more looking at the fact that children who are experiencing types of victimization will often experience multiple kinds. So if you're in a home where you're witnessing domestic violence, polyvictimization tells us that home may also include, mental or emotional abuse, that home may involve sexual violence, that there may be other, elder abuse, animal abuse, all of these other types of maltreatment that our kids are experiencing. And so, when you're thinking about who is coming into our courtrooms, who is coming into our cases, that these kids and teens are often coming from a space where they have been victimized multiple times in multiple different ways. And so when we're looking at technology, there's more and more research coming out. This is referencing an article from 2018, but that looked at digital polyvictimization and the fact that we can no longer isolate or not acknowledge the things that are happening online can be just as traumatic as the things that are happening, real time in the home. And so, like cyberbullying and the sextortion, all of these things that are happening online are absolutely capable of causing trauma. And our adverse childhood experiences a study, that is always looking at expanding sort of that definition of what other things are out there that are traumatizing our kids. That digital polyvictimization piece is now absolutely being considered, that just because it's happening in a virtual space doesn't mean it doesn't create real trauma. And so, knowing that that's out there is important for a prosecution, for a law enforcement investigation perspective, that these elements are causing our kids to have trauma. And like any technology piece, it's tough to really have research because we know technology is rapidly changing. Even in this particular 2018 article, it talks about things that are kind of obsolete at this point, even though they're only just a few years back. So chat rooms, IMing, we don't say that, we say DMs now. But even just references to like computers, laptops are kind of not how our kids are communicating. So it's incredibly helpful to be conscious of it, to be aware that this is something to be considered because it's something that's very real. And so, this research is looking at that component of victimization and found that even though again we're talking in a virtual world, the effects are significant, PTSD, anxiety, other types of symptoms. And then this other piece here that those who had an in-person victimization history were more likely to experience at least one digital victimization from those who reported no in person. So meaning if someone is reporting that they experienced something online that caused trauma, that they were also likely to have experienced something in the home. So, those are things that we need to be conscious of, when we're working this, these types of cases and being considerate of the impact and effects of what it is that they're feeling. And so looking at some quick numbers here. So I referenced this a little bit earlier. These are some numbers from NCMEC, National Center for Missing and Exploited Children. And these were numbers taken from 2019 to 2020, just sheer numbers as far as the exploitation cases that NECMEC was bringing in. And I mean, these are huge, huge numbers. You also can kind of see here the jump, a little bit of a jump between 2019 and 2020. Well, what happened in 2020? Lots of kids were home with access to Chromebooks and everything during COVID. So it makes sense that the numbers would increase, but huge, huge numbers that we are looking at. And one of the pieces that this particular data analysis looked at was looking at who are our kids, who are our victims. And this kind of goes into that polyvictimization piece. Looked at who our victims were. Majority of victims for online exploitation were girls. But that 1 in 4 of the reports indicated that there were other victims, that this particular perpetrator, this particular offender had other kids that they had exploited or were actively exploiting online. And that in looking at the kids who were victimized, that 9% had indicated their vulnerabilities either prior to or at the time of the report, meaning that they had mental health issues, some type of, maybe something at school with an IEP, if a history of online exploitation, meaning that they had already been exposed to something, or had a history of abuse. So, I mean, that is showing the statistics and numbers that polyvictimization, digital polyvictimization exists. So this is a large number of kids that were being looked at and finding that 9%, had vulnerabilities that made them more susceptible and increased their victimization. All right, so next piece here, digging into some of these pretrial challenges, some of these things that are coming up that maybe we can start to tackle, knowing that we have this case and knowing that our kids and families are coming in and having some prior experiences, having some polyvictimization pieces when they are coming into court. We may have an amazing case, the case of my 2 twin girls. I mean, we had rock solid evidence that this was happening, but it's not a slam dunk. We know with all of our cases when they involve kids and teens that even the best evidence in the world is not a slam dunk. So, how can we use some of these things in our legal context to attack maybe some of the not great pieces of that evidence? What can we do pre-trial to combat that? There is a question here in the chat that I will kind of just touch on here because I think it actually does move into why some of these pretrial challenges and court prep pieces are incredibly important. But there's a comment in the chat saying, I have a foster kid who has had similar story to the twins, except it was parents who were involved. It's so sad and overwhelming. He's in counseling. It has been good. My question is, do you think it's possible for these kids to heal? They will never forget. They will have lasting effects, but will they at least be able to deal with what has been done to them and overcome some of this trauma? How can the parents help? That last piece is huge. I think absolutely kids who have gone through traumas can go on to be amazing, wonderful, successful people. That trauma will always be a piece of them. There's never a way to remove that. There's never a way to completely take that out. It will always be a part of them, but it doesn't have to be a part that owns them and controls them. And it really is hugely important to have that family support. The kids and teens that I have seen through the course of my career that have overcome, move forward, are those that have support and are those that have the people in their lives that can be that healthy, safe space and those healthy, safe adults. And so, looking at that, it truly is important to have that support. But then the counseling, the counseling is incredibly important, and not just your, general therapy, sort of the trauma-based counseling. Really digging into the fact that those long-lasting effects are going to be difficult to sort through, particularly if they are bio parents involved. I've had a couple of cases, and I actually have a different presentation on female perpetrators, particularly biological mother perpetrators. And when you have that component involved in a sexual abuse, a sexual assault, it creates a whole nother set of issues because of who the perpetrators are. So it's a great question. I think it truly is that, we never want to give up on these kids, and we never never want to tell them, sort of going back to the language at the beginning, that you're a victim, you're always a victim. We know that there are things that can be done to get them to a better space. It's a tough road though, and it's not an easy road. So, I commend everyone that is involved in that, particularly the person who asked the question is a foster parent, and, really being that stable, safe adult will go really far to increasing that healing. And then there's another question as far as the numbers and NCMEC numbers with things opening back up in 2021. Have the reports gone back up or back down? And I don't believe NCMEC has done a huge kind of data dig into the recent numbers. So those we're looking at 19 to 20. I think they're in the process of putting those numbers back together. So person that asked that, I am jotting myself a note to get you an answer on that. I think it is that they haven't quite gotten there yet. But I think I've also read some things that numbers kind of just stayed up, that the continuing exploitation of kids just continues to increase. And so I will get you a firm answer on that. As I sit here right now, I don't 100% know. And so I want to make sure I'm giving you good info. But those are great questions and great things to raise. All right, so some, again, these pretrial challenges are things that we've already just referenced a little bit. And, really that pretrial challenge, you can start working with that family, working with those kids as soon as you possibly can, using that time pretrial, while it's been charged and while it's pending to increase that trust and to build the trust. So you want to start from the beginning, especially again in the prosecution context, in the investigation context. We want to be able to start that communication piece as soon as possible. And so, even just building your team, even increasing that communication is going to help that trust be built. Just the simple things of having information about their case, knowing when things are set, knowing who their victim advocate, knowing who their prosecutor is going to start creating that trust. Because we know that victim cooperation can often be one of the bigger hurdles, one of the bigger obstacles to our cases. And, particularly again, in our human trafficking cases where kids may be, coming from a space where they don't trust law enforcement, where they don't trust prosecution, they're coming into this with that existing distrust. Getting that cooperation can be really difficult. And so, if you find yourself in a situation where even though, you're doing everything you can and you're trying your best, sometimes things aren't going to be doable with your victim. And that can be for any number of reasons. I've had a number of cases involving trafficking where it in that time has been best for that child, that teen, to maybe go into an intensive treatment, to maybe somewhere that it's almost like an inpatient. And, they are doing that and they are unavailable. There are things that we can do to try and argue we can move forward with that trial without them being actually present. But, there are circumstances that are going to take our kids and our teens and our victims to be unavailable. And so, also too, we have situations, unfortunately, again, in our all of our cases, but, in our trafficking and our online exploitation cases, where maybe there is issues with alcohol, with drugs, and not stability, where we can't find our victims. We can't find them. We don't know where they're at. And so, you have to then be thinking, is there a way you can move forward with this case without the victim? Can you prove that up? And, considering the fact that the trial itself is going to involve some pretty tough cross-examination, from the perspective of the victim, that can be the most traumatizing piece, that they're going to have to go into trial and not only talk about what has happened to them, but then be cross-examined about it. And so, you want to be conscious of these things. How difficult is it going to be for them to move forward, and what can we do to either soften that blow, or is there a way around it? And maybe there is a question of looking to statutes that don't necessarily require the victim. Are there things that we can do that are going to successfully prosecute this particular offender without the victim? And those are things that are kind of outside the box, thinking like your money laundering, conspiracy, things that are not necessarily requiring that excuse me, victim's testimony. But those are generally not going to be as severe as punishment as your hands-on abuse, your online exploitation. So you want to look at other ways that you can do this, and you want to then work your case to corroborate a sexual assault, to corroborate your online exploitation like you would a sexual assault, a homicide, domestic violence. What can we do to build up this case as much as possible, so that if, when we get to the time of trial, if there's something going on with victim, if we can't move forward with victim, is there maybe something else we can prove up? Or is there, something that we can make a good forfeiture argument, meaning, defendants' actions themselves have created a situation, circumstance where that victim is unavailable. There are things that we can do, but we need to have that good corroboration. We need to have that good case that is built up. And so we want to, have that started, and have that that in the back of our mind. If we don't have a victim, what can we do? This is a great publication that I found just in doing this research through National Institute of Justice. This is a detective out of Texas that really looked at ways to reduce the need for victim testimony in human trafficking. What can we do to prove that case where we don't have to call that victim into court? And being conscious of those struggles, understanding why it would be so hard to talk about what has happened to them, and to really process through what is going on. That sometimes it's not the fact that they are liars. We have that often painted, unfortunately, so much that if they're not being cooperative with prosecution, it's because they're lying. And that's not the case. It's just that there's so many mental health things that come along with this process. And so, working with your mental health, the people that they are working with in that continuum of care, the other therapists, other counselors, if there are rape crisis counselors that they've worked with, if there's a person that your victim is relying on, that their victim finds is supportive, do what you can to work with that person. So like, hey, same team, we want what's best. We want to obviously prosecute this individual who has perpetrated these crimes, but we do understand that there's a lot that goes along with it. And there is a long journey to that recovery, which is, again, the great question we had earlier. It's not an easy road. And so, having that involvement, I've kind of, hit this a little bit as far as your continuum of care, really being able to have that team on board, as far as, having a space that is going to be a healthy space if we have to go to trial. So, then we can take this as prosecutors and use, some of these sword and shield things, the things that we want to aggressively move forward and make sure come in as all our great evidence. But there are things that we want to prohibit, that we want to bar. And this can work two ways. Obviously, if we are successful and are able to limit the things that a defense attorney can get into on cross-examination, that's going to be more beneficial for our case. The other piece is that it does show your victim, your families, that you're fighting for them, that you are trying to keep out things that don't matter, that you are trying to protect them, knowing their traumas, knowing their past history, that you're doing what you can to ensure that when they go into that courtroom, they're only asked things that are relevant. They're only asked things that matter, and that it's not just a smear and a fishing expedition. So, a couple of these motions that are incredibly helpful. Motions in limine on any type of prior abuse. So this is your rape shield. Like we just talked about with polyvictimization, we know that there's often prior cases, prior instances, prior things that are occurring. And so if you want to keep those out, if you want to have abuse by another perpetrator kept out, then that's a great motion to file. And most often it's going to be successful, especially with our kids. The only time that a rape shield motion may not be successful is if there's some type of consent argument. Obviously, we know consent is irrelevant when it comes to kids and teens for hands-on as well as online exploitation. So generally, if this is something you want to keep out, you will be successful in this motion. I had a case where during the time that my girl had been sexually assaulted and our perpetrator had solicited images from her, so it was a dual online exploitation as well as a hands-on case. Between the time that was reported, charged, and the time that we went to trial, she had a relationship with another teenage boy and got pregnant and had a baby. And I knew that I had to file a motion on that because the defense attorney was absolutely going to ask for it. And we argued it, and the judge agreed with me. It was kept out. But that was one of the issues that then went up on appeal, that was noted on appeal, that was something that, was properly kept out. So, using that will keep some of that, just kind of smear things out. If there's mental health issues at issue that are not relevant, then that's something maybe that you're filing a motion on. That there's no reason to get into if victims counseling records are something you don't have access to, and maybe they were in counseling or therapy before this happened. There's any number of reasons why we would want to restrict that testimony. So filing that motion. A lot of times we see that defense attorneys will go on, again, those fishing expeditions, that they'll ask for things like medical records, school records, DCFS records. And oftentimes what's going to happen with that is, you can file that motion either barring the subpoena or asking for something called an in-camera review, which basically means that the judge reviews it. And then the judge determines if there's anything that may be relevant. But then there is an extra step that you can file a subsequent motion, another motion, and say, okay, the judge has determined that these are relevant, but maybe they're not admissible. What does it matter if they skip school? What does it matter if they, had a doctor's appointment? Whatever the case may be, the facts may be, if they're not relevant, it shouldn't come in. And then the last piece is something that always comes up with our kids and teens. These other people. How many times do we as prosecutors get this witness list from the defense, and it's a whole bunch of people that we've never heard of, have no idea who they are, and you reach out and call them or have your investigator go talk with them, and they say, well, I'm going to testify about how that kid's a liar. I'm going to testify of how I know this absolutely didn't happen, and this defendant would never do anything like this. That's irrelevant. That's up for the jury to decide. The jury is to decide who is believable. The jury is to decide who is guilty. And so, if you get some of these witnesses, some of these people that are only out there to just come in and say, I think they're a liar. That they're, one time I saw them steal something, and so therefore, I want to come in and tell the jury about this. There's a lot of great case law all over the country, lots of jurisdictions that, specific acts of bad conduct, specific things are not relevant and not admissible. There's something that gets into character or reputation evidence, where someone, if they're going to come in and testify about that victim's reputation in the community, that's a different story. But most often these specific acts, the person's opinion, the witness's opinion, is not going to come in as relevant testimony, as testimony that's going to be admissible in front of a jury. And as well, it shouldn't. It's up to the jury to make those determinations. And then the last piece here, I would have on here, consider an expert. And by consider, I mean get an expert. All of these issues that we've talked about, histories of trauma, polyvictimization, the fears with particularly our digital online exploitation crimes, those are all things that, as those of us that do this work all the time, know that these are things that happen. These are things that come up. Oftentimes your average jurors don't understand it. They don't have a background or an experience with this. They don't know anyone who's experienced abuse. Sometimes some of your older jurors may not understand some of the tech components or how that works. Grooming is something that is hugely important in showing in our online exploitation cases. And so, thinking of how you can use an expert. Are you going to use an expert for, dynamics of abuse? Are you going to use an expert to talk about, how some of these online platforms work, and how that access would be really easy to have? Are you going to use an expert to talk about why victims of human trafficking are susceptible to having kind of a law enforcement bias if there's been prior history, all sorts of things. There are really great ways that you can use an expert to fill in some of those questions that jurors may have. And in this case here, this is the case that I just kind of referenced, talking a little bit about my victim who was pregnant and had the baby by the time we went to trial. But I had called an expert because there was, a large number of things that we really wanted to talk through as far as dynamics and grooming and interaction. And, we talked a lot about response to abuse. And this particular victim's response included some things that might be contrary to some jurors' understanding. She reached out to her perpetrator while this was pending. There was some other things that we really needed to talk through. And so, we had her come in and testify, and she talked about, response to abuse and how it's different when that perpetrator is someone that they trust. If kids are coming from a chaotic environment, in this particular situation, my victim was a foster kid and had been in foster care for a number of years. And so, she didn't have a stable environment. She didn't have a stable home. And when this particular perpetrator came into her life, they exploited that and used that to be able to talk about, or that he used that to ingratiate himself in her life. And so, we use an expert to fill in some of those blanks. And then in closing, I pulled back to all of it saying, you heard the testimony of our victim and all these things that she talked about. And then you heard an expert come in and tell you how all of those things were not reasons to disbelieve her, but more reasons to believe what our victim is saying, because it fits what we know about dynamics of abuse, about kids' response to abuse, especially kids in chaotic environments. So experts can go really far to helping you fill in some of those. And one of the things we do through Zero Abuse Project is helping, hey, do you have this expert, or do you have this situation, and you need an expert, you need help putting together a direct examination for your expert, how you can use those things. That's absolutely something to reach out and talk about. All right, so a kind of last piece here before we get into the end, a little bit about trauma-informed trial prep. There's a couple of things in the chat. I did see one that says, please read the entire question. We can't see all of them. I apologize for that. There's a question about policy initiatives. What policy initiatives to remove investigative barriers like sexual exploitative images remaining online forever in these criminal cases? That's a great question. And as our legislatures work more in partnership with our tech providers, there is more success. There is, and again, this is another one of those topics that gets really far afield, but there is a lot of pushback sometimes from privacy advocates that have issues with our tech being able to screen images that are coming. And so there's always sort of that push and pull, but there is active work, and there's a lot of really great organizations that are doing great work to balance those sides, the protection of kids as well as, those privacy concerns. And then there is something also in the chat. I'm glad you're talking about this. I feel individuals should have the right to not share their story if they do not wish to. And yeah, I mean, that's an incredible point, and really, I think, shown in these particular cases, especially those cases where that disclosure hadn't happened. I have, again, through the course of being a prosecutor, met with hundreds of thousands of kids and families. And, I would always tell them, at the end of the day, you're the one in that witness chair. It is your life, your family, your story. I'm just the one asking the questions. And yes, I want to achieve justice, and I want this perpetrator to go to prison, and I want to, be the person that is going to help close this for you. But I understand it's not me that's telling my story. I'm facilitating that story. But sometimes you have to look to the people who are truly involved in it and understand and respect their wishes. And I'm telling you, I don't plan these questions, but that is a great kind of transition into that trauma-informed prep, because so many times we know that people have a ton of anxiety coming into court, not wanting to testify, not wanting to be involved. And rather than just saying, okay, like, we're not even going to bother, there's some really great things you can do to get to the place where that victim, that family feels ready to go in that courtroom. And so, going back to that trust, you really need to build that trust. They have to trust that when that time comes, if you have to walk into that courtroom, they have to trust that you are going to do the best you can to protect them as a victim, but to fight for that justice. And it is so hard with our jury trials. We don't know, we never know what's going to happen with the jury trial. And with every family, every parent that I sat down with at the beginning of a case, I would always say, I cannot guarantee what's going to happen with this case. I can't guarantee you it's going to plead. I can't guarantee it's going to go to trial. I can't guarantee that if we go to trial, even if we have amazing evidence, that a jury is going to convict. I just don't know. What I can guarantee you is that I'm going to do the best I can, that you, your family, your child feel that you were heard and feel that you got justice through this process. That I can control. I can control what I do. There's a lot that I can't control, but I can control that trust and control that communication. And so, if you start building that when you get to the point of trying or getting to, actual trial prep, you're doing everything you can to reduce that anxiety. And so I want to get to a couple things here that are incredibly helpful for our kids and families coming into court. So first off, support person, you absolutely, want to designate someone as the support person, the person that's going to be in that courtroom, that every time I am, prepping and getting ready, I want to know who my support person is and where they're going to be. So I can tell that child, that teen, hey, if you need a second, if you just need to look for a friendly face, you know that Aunt Joan is going to be sitting right here. You know, victim advocate Tiffany is going to be right here. That's where, you want to have them have that space, that they know who it is that's going to be there and where they can look for someone. So, who that support person is, figuring out, and then, having that position is great. So we know support people are fantastic. They are really great to being that person. But I'm also a huge advocate of our furry four-legged support, not necessarily people, support animals. I say four-legged. I know that there's like support animals out there that are maybe two-legged, but primarily the ones that I have worked with, and this one in particular here was Fitz, our English Labrador, who is our facility animal. And it was incredible as far as taking some of the stress down and giving kids, families, just something to sort of ease their mind and to help, even just in early meetings. It's really tough to remain stressed when you have this, wonderfully comforting presence that's just there for you. And so if you have a jurisdiction where you have a facility animal, amazing. If you don't, I'm always willing to talk through, how they can happen, because they're incredibly helpful, incredibly effective. And there are certain states that allow the use of support animals during trial. February 2021, American Bar Association came out saying that this should be best practice. More and more jurisdictions should be using it. And so, again, using that animal in your court prep, in your witness meetings, all of that is only going to be beneficial. And so, knowing if you're using that animal, involving it from the start and involving the parameters. So, your child, your victim knows exactly, are they going to be in court with you? Are they just going to be at meetings? Or are they going to be waiting for you when you come back in? Those kinds of things to work through. Um, and then, in your final prep pieces, a couple other things, deciding if you're going to review the video with your victim. There are jurisdictions that either, that may be limited, but most of the time I would argue that it is no different than any other witness that's coming into court. If your witness gave a statement to the police on a hit and run case, you wouldn't go to trial without letting that witness look at their statement, especially if their statement was made 2 years ago. And, the argument sometimes is that, well, that's just planting memories, and then they're just going to testify about false memories. But this is a statement that they made at the beginning of the case. We wouldn't be here if that statement hadn't been made. So, sure, there are definitely things that you have to be conscious of. If there's something that, while you're viewing the video, that child says, like, I lied about that, then yeah, that's something that you need to address. But if it's from just a memory perspective, every kid and teen that I've watched their video with, they've always told me, I would never forget it. I remember everything. And it never fails that there's something that is said of them remembering and saying, I forgot about that. I forgot that that happened. And so, if you were going to do it, again, going back to that plan of mental health, there were a number of times where, I would be in communication with a child's counselor and say, hey, we're going to watch the video on this date. And then they would work to have a session, even if it was just a virtual session that night or the next day, whatever it was to be conscious of that. In your prep, letting them know what questions you're going to ask, letting them know what things you think the defense might ask, and that it's okay to practice. I really enjoyed doing, or not enjoy is not the word I want to use. I really saw great effectiveness in almost kind of doing some mock trial stuff and doing things that were a run through. And we would get, people from our office. To sit in the jury box just so that they get the understanding, the feeling of testifying in front of a live audience. We do a little bit of cross-examination piece, and again, if there is something that came up where there is a additional information or a retraction, whatever, that yes, you are ethically bound to disclose that. But being able to simulate as best you can what they're going to expect is going to go really far to reducing that anxiety and reducing that fear. Um, Knowing what exhibits you are going to use, what images are going to use, especially in cases if you have to show images of child sexual abuse material, images of exploitation, you never want to just like throw those up on a big screen with your victim sitting there. Come up with a plan, come up with a way that you can do it. In the case I referenced with my foster girl, who we had images that she had sent our perpetrator, the way that we did it was I essentially had them for her to identify herself in them. We went through and we obviously, talked about this before, so she knew that this is what was going to happen, that I was going to show her, People's Exhibit 14, 15, 16. Is that you? She was still under 18. So, at the time she testified. So she identified herself in them. And then we had the detective come in. So she's no longer in the room testifying. The detective is the one who found them on the phone. And so she identified herself, but then he continued to lay the foundation. And that's when they were actually published in front of the jury. And it was very important to us to not have to put those up on the screen when she's sitting in there. I mean, I can't think of, if we think a trial is traumatic, having to sit in that trial where your naked pictures are on a big screen is incredibly traumatic. So, having that plan, having that understanding will help, so they know what to expect, and that reduces a lot of anxiety. All right, so this last piece here, and then there's a couple questions, and we will have some time here to pull through some of those questions. So these last couple pieces, though, I wanted to hit on because it's sort of the end. What are the things that we can do? And this sort of goes into the question about what is being done, legislatively. What are some of the things that we can do after the fact that help these victims? So a couple things to hit on here. So the notification process, talk a little bit about asset forfeiture and restitution. So notification, what I mean about that is, once these images are identified as known images of child sexual abuse material, there is something that is attached to those images. It's called a hash value that basically identifies that image as that child. And in the databases, it's included that if that is a known image and that child is known, if there is a contact person, because every time that image comes back up in an investigation, that detective, that law enforcement person will be notified that, hey, this came back up again. And so you want to come up with a plan for your families, for your victims. Do they want to be notified? Do they want to know every time it comes back up? Do they not want to know? And this is something that can span for years. And so, having some of those final conversations about, hey, if this comes back up, where we hear, like the example I used right at the beginning, 6, 7 years later, that video came up. Do you want to know? Do you not want to know? Talking through a way that's going to be trauma informed for them. The ones that I really hated was when we would get a notification and it was a case maybe before my time. How do we contact this victim? I never just want to send a letter saying, hey, your video came up again. Coming up with some plans that can be trauma informed. Restitution can be great. There is lots of statutes as far as federal restitution, but more and more states are putting it into their laws that victims are entitled to be compensated if their images continue to come up. And I've had cases where I have charged an online where someone was pulling images offline and viewing them. I've had those cases be charged, and then a victim's attorney has reached out to me and said, "Hey, I represent the victim that's in your count for." And in those cases, if I had bond posted, if I had a way to get them restitution, we would do it. There was one particular victim where my defendant had posted 10,000 cash in bail, and she got a $10,000 check when we wrapped up that case. So it's out there, it's able to be used, and can really be helpful. Sure, we know that we can't undo the damage, but if we can provide things to those victims as far as restitution, it's really helpful. And so if there is a victim's attorney that's involved, outside of the prosecutor, someone that's their private attorney, that can go really far into that communication piece. And then the last is asset forfeiture. We talk about asset forfeiture so much when it comes to our drug cases, but we don't talk about it as much with our child exploitation. And in most codes for asset forfeiture, online exploitation is part of it. My case that I talked about at the beginning with the twins, that house that he lived in, he owned clear outright. And when we charged him with all of those counts, we also took his house. The house ended up getting forfeited and was sold to fund a new firing range for our sheriff's office. So, not forgetting that there's things that we can do to not just criminally charge them, but to remove the ability that they are ever going to, be able to, one, profit, or two, use that to harm another child ever again. Our couple of resources on here, like I said, I would throw something up here about our website, so I'll leave that, but we've got a couple minutes left here, and there's a few things in the chat that I'm going to jump back over. There's a couple comments just about how being heard is really important to the process. A comment that really is the hardest part sometimes, knowing something happened and that a suspect is going to walk, but it is crucial to try and respect the survivor's desires and rights as much as we can. As a victim advocate, law enforcement officer, that's been a struggle. I have had a number of cases. One that I think of just in particular here, I had a little girl who was 9, and we were getting ready to go to trial, and she had a break, and she ended up essentially trying to commit suicide and went into a facility. And I, could balance, hey, do I continue this and continue to hope that she's going to be better, or do I figure out a way to just get a resolution on this case without having her go to trial? And, do I know that that guy was guilty and should go to prison forever? Absolutely. Did I plead it to probation? Yes, because, in that moment, we needed to be more conscious of our child's needs. So it is a big struggle. It's incredibly difficult. One of the questions, how do you manage countertransference, emotions, reactions to a story as a prosecutor in these cases? That's probably a whole nother presentation, as far as our prosecution and the secondary trauma, and taking in a lot of this. There is no easy answer. This is recorded, so I don't want to get too into specifics, but there is no easy answer, and it comes, I think, with practice. After having done this for a number of years, you are able to disassociate, unfortunately. In a lot of spaces, you have to do that to be able to do your job and do the things that you need to do for your kids. But as always, I'm a counseling advocate because we know that these are really difficult. And then a last question, I think, in here, do you have any suggestions for in-home care coordinator working with young boy polyvictimization by mother, residing with father and stepmother? Both are unable to understand now sexualized behaviors, looking for support for both the youth and parents and understanding. And then there actually, I think, was a good comment here talking about trying to get those parental support groups. More and more multidisciplinary teams are getting into that professional or the parental support group, the caregiver support group. And so I think, just in interest of time, that's definitely something that if you want to reach out, I would love to chat with you a little bit more. But getting your caregivers to understand that it is problematic. It's tough, especially if they don't truly understand. Feedback from judges regarding support animals in the courtroom. We're all completely on board, or was there some pushback initially? Judges were always on board. Defense attorneys will never agree. I had a number of defense attorneys who made a big show of being supportive and financially supportive for the facility dog. Those are the ones that were the most voracious in their filing of motions against it. So it's definitely something that you have to argue. I've got some great resources for a motion for a non-pattern jury instruction that can help. With assets taken as a proceeds placed in trust for the victim. So asset forfeiture, since it's a civil process and the money goes through, there's actually like statutory guidelines as far as who the money goes to. There are some statutory guidelines that have it, part of it go to victim, but it just sort of depends jurisdictionally. All right, and William, I know, needs 2 minutes. So I think I am at 2 minutes to allow William to wrap this up. But again, email, I'm going to throw that up there. Please, I mean it. If you want to reach out, chat, talk, contact me, and we will make it happen. All right, William, all yours.
All right. Thanks, Kathleen. So to our audience, thank you so much for joining. Again, thank you, Kathleen, for providing our audience with this much needed and very important information. Before we exit or end today's presentation, if everyone could please go over to the control panel, expand the polling control there. You'll see my colleague has put up a poll question. Before you exit, if you could, please take a moment to complete that poll question and provide us some feedback. Just a reminder, like I mentioned at the top of the presentation, remember that you all will receive a certificate of attendance for attending today's web event. So please be sure to be on the lookout for that certificate. Also, if you're looking to get in contact with OJJDP's INTAC, please be sure to go to this URL, and we do encourage you to sign up for our listserv. We encourage you to also go to OJJDP's website, ojjdp.ojp.gov, where you'll be able to see information about just OJJDP overall, about their Just listserv subscription that they have, and also about their upcoming events that they have as well. If you're looking to get any information about OJJDP overall, we do encourage you to please reach out to the help desk as well. As a reminder that this webinar is recorded, this and other webinars are available on OJJDP's multimedia page, where you can go there and view webinars related to juvenile justice and child victimization prevention. We also encourage you to please go to the to the TTA Help Desk in order to get access to any support materials. Just a reminder that we do have another Zero Abuse webinar coming up this month on the 19th, so please be sure to register for that webinar if you haven't already. We also have another Zero Abuse webinar coming up in November that we encourage you to please register for as well. And then also in November, we have 2 additional Zero Abuse webinars following up on investigative and judicial practices, and also interviewing children with disabilities. So please be sure to go and register for each of those webinars as well. And as always, we do encourage you to please stay connected with OJJDP via these multiple social media and newsletter and listserv channels here that you see. So please be sure to go in and follow OJJDP as well there. Take care, everyone. Thank you all so much for your time today. Have a wonderful afternoon. Bye-bye for now.